Rick Hollow to consider my comments today, and if there is a move to by this commission to ask for a redo, that it come about next Monday.
John, am I hearing you correctly? Has the News Sentinel dropped the lawsuits against us as commissioners or as individuals? Has that already been done? Is that official, or are they just proposing?
No, it is going to be done. Rick Hollow agrees with me that that commissioners should not have their personal pocketbooks at stake, basically, for actions that they took as commissioners. And I struggled with that part of his lawsuit, and have for 3 weeks. I didn't really understand it. Certainly, I don't believe that you can violate the Sunshine Law as an individual in your personal capacity. And he can sue you as officials for your official actions all day long. But your official actions are Knox County, as far as my representation is concerned.
So that's something they're going to do. They just haven't done it yet.
That's right. That's right.
Do you know?
It is not part of this settlement. They are going to do that whether there is
settlement or not.
Response to this settlement offer or
okay.
not.
Commissioner Moore.
We have a motion on the floor.
I think we have a motion.
Do we have a second?
Will you restate your motion?
My motion is to place this proposed settlement on the county commission agenda for the 26th without recommendation.
Are you wanting to add that as a discussion item, or just to place it on there?
I would like to place it there without recommendation, but we can add it as a discussion item.
Well, it'd just be. We can go with no recommendation. I was just asking.
Are you asking? You want action on it? Up or down vote?
I think it would be very good to have a vote at that meeting, so that's why I'm making it done without recommendation.
Do I hear a second?
Second.
Second.
Mr. Chairman, I make a substitute motion that we do not put this on the agenda, and that we, in the future, we want to talk about it. I don't know if we can talk about it, but I think we probably need to use the executive session.
Well,
would you please?
All right. This is one of those things, and I've thought through that process about having an executive session to talk about this. There's nothing that I've said today that's not in this letter from Rick Hollow and that do not address my thoughts that I would share with you in executive session or open session or on the street corner or anywhere else. There needs to be, in my opinion, a public vote as to whether to accept a settlement offer or to make a counteroffer. And so that's why I brought it to the attention as a public body. Certainly can meet with the body in executive session.
You can meet with individual commissioners, can you not, in your office?
I can meet with a group of commissioners, individuals, however you want to call it, to discuss litigation. And we have very specific and strict rules that we live by when we engage in that conversation, basically. And it's pretty much a one-way conversation. If we stray from those rules, then it's not commissioners who actually get condemned for their actions. It is my law license, ultimately, that is at stake. And I take that matter pretty seriously, too. We can have such an executive session, but
John,
it will be mostly my communication with commissioners, and commissioners are not permitted to talk with each other during the session, and so on and so forth.
John, and that was my question. There may be some people who have some questions they want to field to you for research.
And they're welcome to
and for you to be
come
able
by
to
my office, and they're welcome to call me. And, I mean, I talk with pretty much each of you on a weekly basis.
But just looking at the proposal, this is the worst-case scenario in any court they could hand down, the redo. I mean, that's the worst they could do to this commission, other than drag us through depositions.
What I'm telling you by my comments today and what Rick Hollow is telling you is there appears to be one way to resolve a violation of the Sunshine Law.
But we don't know that there's been a violation.
That's correct. That is correct. But If we wish to address it and address it ourselves, the way that you do that is through a redo. And it's difficult because we have 12 persons that were appointed at the January 31 meeting. It's extremely difficult, but it can be done.
But I would argue, Mr. Law Director, that you don't bring back I don't see how you bring back the 19 O's. I think you end up with 11. And I think that'd be a court case in itself to see where we're at.
It's possible, but what you have to do, and from a legal perspective, what you have to do is to go back as we existed at 9 a.m. on January 31. And if you go back there, then all 19 commissioners are still in office. They're still able to vote on their successors. And you do. You still have the other lawsuit that is pending against the new 12 that was filed within an hour of the swearing-in ceremony. That lawsuit is still there. That lawsuit also contains sunshine law violation allegations, which I believe a redo would cure those as well. It would certainly lay those issues to rest. There's certainly no admission that there was a violation of the Act, but this is how you cure an alleged violation of the Act. This is the process.
Other than the redo, are there any other
counteroffer?
Well, no. Are there any other things that they're wishing us to do?
The Knoxville News-Sentinel?
Yes.
Yes. I mean, you'll see in the letter where they have basically they pretty much spoon-fed us on what it takes or what their position is, what it takes for a redo. And they would also ask for an injunction, which is part of the relief in Chancery Court. They would ask for an injunction against the Knox County Commission instead of against individuals. What I would suggest is that there be some limitation on any type of an injunction. For instance, a 6-month injunction against Knox County Commission, I believe I could recommend to resolve a lawsuit. And actually to resolve this lawsuit and part of the suit that was filed on January 31. I do not know if Mr. McElroy would accept that. I do not know if his counsel would recommend a certain restriction on an injunction or basically a time limit on an injunction. But that's what I would recommend that the body do instead of having an open-ended injunction.
I would suppose that in order to have a redo, we'd have to go back to the laws that pertain to appointments, which would be at least a 10-day notice.
That's right. All the notice provisions would need to be complied with. As part of this process, I think Mr. Hollow suggests that there at least be some opportunity for persons to present their credentials to the Commission, and that's also part of the settlement offer. That's their offer, and certainly the Commission can meet and give me authority to make a counteroffer.
Well, we'd do that we could possibly do that Monday or...
Mr. Chairman, I think we've got a motion on the floor not to add it.
Well, you've made a motion. You've made a substitute motion. I don't know if we've had a second to it yet.
I'll second it.
Okay, we got a substitute.
I have a question for the law director.
Okay.
Also.
Mr. Lambert?
Yeah, Counselor. Can we even accept this offer? Because I'm not a lawyer, and really, don't have a lot of training in that area. But it just seems to me that the county commission does not have the